Hi, good afternoon. This is Dr. Kishore, working as Assistant Professor in Physics, Department of HNS, and member of Center for Research and Innovation, KSRM College of Engineering, Kadapa. Now I am going to discuss about intellectual property rights. So you have an idea, suppose, and you want to commercialize it. Then what you have to do? First, you need to protect your idea. So let's find out how to protect our idea. Okay, so to protect your idea with IPRs, three things you need to know about IPRs. So what are that? First one is IPRs are more than one tool. IPRs give you control. IPRs are country and specific. So it depends on the location also. See how IPRs apply to you. Very simple. Let's get started. I am an individual creator and inventor. It's applicable to you. If you have a business, then also applicable. If you are belongs to university or researcher or a teacher or a faculty or a student, so for anything, okay, it depends upon the area of working and whether you are individual or a businessman or a teacher or any educator. So for all the people, the IPR is applicable. Suppose now, if you are individual, okay, IPR can help you access and navigate the market. Before you set out on your IPR journey, ask yourself, we have to ask ourselves, has this been done before? First you have to check it that before going to the IPR, so intellectual property right. Understand? So what we have to do? First you have to find whether it is available or not. Is there a market for my idea? So that is very important, because if you think something and if don't have any market, okay, without any use of that, if you want to go to IPR, it is a waste of time. Understand? So is there a market for your idea? That is also you have to do some research. Do I own my idea? So it belongs to you only. How can I protect my idea? This is very important. That is called IPR, intellectual property right. Understand? So how can create value from IPR? Very simple. Once you gives up a certification to your idea or any product or anything, then you go for the business model. Okay, so these are the things you have to keep it in mind. The first one is, has this been done before? Very simple. So first you have what you have to check. You have to check it whether it is before done or not. Is your design really new? That is important. Is it innovative? Right, innovative, new. Okay, so these two words are very important for if you want to file an IPR. Check what IPRs can exist before applying for your own by searching IPR database, because IPR database is open database, so anyone can search it whether any product is available or any idea is available or not in the IPR. Do others have rights that can stop you from protecting your invention, design, or trademark? This is also known as checking that you have freedom of to operate. That means you can oppose. Suppose somebody file the certification on your product, so you can oppose, you can show some with the proper documentation and proof you have to show, right? So next, search IP data. How to search the IP database? See, so to identify existing IP rights, so first you have to go to patent score for inventions. Global brand database is there. Global design database is there. So it depends upon the type of intellectual property right. You have to search in that website. Understand? So like that you can check whether it is available or not, or World Intellectual Property Office. You can check it here also, right? So like this, uh, so now next what you have to do, is there a market for my idea? Yeah, that is important. Before going to patent, or if you want to do any certification for your idea, then first you have to do some research whether your idea is marketable or not. IPRs can support your business goals, but how you are going to use and manage them, very important. IPRs are an investment for your future. This beyond today. Okay, just you think beyond today. Choose the right IPRs that are needed to protect your idea. Very important, because we have so many intellectual property rights. Okay, Indian IPRs are there, worldwide IPRs are there, US IPRs are there. So like that, we have different types of IPRs. So wherever you want to do business with your product, you have to file the IPR. Before you share your idea, always conclude a contract such as a non-disclosure agreement (NDA). This is also called NDA with the IPR. Document your idea as it evolves. So this document evolve an idea, okay, and it will be protected. So how to protect your IPRs? Very simple. See, these are the rights to consider if you have. Okay, if you want to file any, if you want to give any protection to your idea or any product, okay, any trademark. So these are the rights to consider if you have. One is first one is an invention. Okay, so in the invention, what type of are there? Patents are there, utility models are there, trade secrets are there. Next one is a creative work. Work also we can do the IPR. So for that is called copyright. So usually you will do in the publications. Research publications are copyrighted, right? Like textbooks also copyrighted. So like design rights, some things if any new design is there, okay, building design or any machinery design or any product design is there. Understand? We can go for the creative work certification or IPR. Okay, so this called some. These are different types, right? So a brand name or logo. Suppose if you take Coca-Cola, it's a brand name. That's name no one can use directly. Okay, so that is belongs to only that company because they trademark that logo. Next, in brand name also there are some copyrights. Okay, they may their product they copyrighted, sometime patented, copyrighted, trademark the designs, signature. We call it trademark as a signature of the company. So then design rights. If anything is there, if anything is there, understand. So you have to do any one of the certification of all these types. Understand? So here the confidential information also we can do the trade secrets, and next one is design. A design can be design right you can do, copyright you can do. Understand? So like that we can do different types of certification in the IPR. Here another new one is a new plant variety. So this can also you can do this certification in the IPR, plant variety protection, patents. Okay, so like that we have so many types of rights. Okay, all this you can call it as intellectual property rights. Now come to the individual. As a individual, I already told you, do I own my idea? This is another part you have to remember. Okay, am I entitled to IPRs? Yeah, beware, you should know that ownership of IPRs is not always straightforward. That means directly they won't give any right to you. It is independent. What you have claimed, okay, an inventor, creator, design is not necessarily entitled to the associated IPRs. Sometimes they are automatically assigned to your employer or entity that hide you. Understand? So that depends upon the how you are filing the this IPRs. Understand? Next, if you want to know the more on ownership, so inventorship versus ownership, very important to know if you want to file any IPR. So clarity on ownership is essential in enabling you to leverage your IP assets. Next, business settings. So this is the first point. By default, the inventor is the owner in many countries. If you want to use an invention, you need to own it or have the right to use it. Companies usually require employees to assign their IPRs as part of their employment contracts. Sometimes, suppose if you take in university settings, ownership is determined by national law, university intellectual property policy. Okay. Next, employment contracts. So, and individual contracts with industrial partners. This depends upon their what type of contracts they have between the employer and employees, right? So this depends upon the various factors. Ownership and inventor may be anyone, but ownership depends upon the contract between them. Understand? Now come to again here. So how can I protect my idea? Very simple, very simple. So we can protect your idea with the IPRs only. Okay, so three things you need to know about IPR. What are that? IPRs are more than one tool, not one tool. Okay, IPRs give you control. IPRs are country specific, it's not universal. Understand? Next, how can you create value from IPRs? Yeah, this is very important. You have acquired your IPRs, how are you going to monetize them? Okay, here are two ways you can do this. One is licensing, another is selling. If you want to generate income from licensing, okay, so then you have to do some licensing of your product. Then you can sell to them. If you need an injection of cash, or if you don't have the capacity to develop your IP asset, that means you are unable to develop your own product, then you can sell your license to somebody. Okay, that means your IPR, so intellectual property, can be sold to anyone, so they can produce the your product. Okay, so these types of in this way you can get the money, or you can acquire the value to your product, right? So how can I enforce my rights? Very important point. Enforcing your IPRs. Your IPRs have value. Defend them. As the IPR owner, it's your responsibility to monitor for infringing activity. Checklist. This is very important. Identify key unregistered IPRs and ensure they are documented and contractually protected. Ensure you can prove ownership of your IPRs. Monitor the market and competitions who may be using your rights without permission. Gather evidence to verify the infringement and seek legal advice. Okay, and decide how you are going to tackle, very important, infringements, and act quickly. Bear in mind that you can turn an infringer into a license. Okay, next, ways to monitor and enforce your IPR. This is very important. Once you file means, okay, if you will not monitor, it will be used by someone, or they may claim again. Okay, because IPRs are not for lifelong. Understand? There is a duration of time for every type of intellectual property right. Consider working with a brand protection firm or an IP firm to monitor the internet. Familiarize yourself with the notice and take down provisions of major online platforms, because you have to monitor all these things. Watch out for look alike domain names. Consider alternative dispute resolution. It's a cost and time efficient way to resolve disputes outside the courts. Apply for customs protection to tackle counterfeiting or piracy. Go to court, involve law enforcement. So this way you have to enforce your IPRs, right? So that is about individual IPRs. Suppose if you go to business type of IPRs, has this been done before? It's the same thing you have to do. Do I own it? This is the same thing you have to do in the same similar way. Is there a market for my offering? This is very very important in case if you want to do any business, because here main motto is business only. Understand? So with along with the idea, you should know whether this is capable of getting the business or not. Understand? Then you will be able to protect your idea using the IPR. Already I mentioned what you have to do. How can I create value from it? Very important. I already told you same thing is applicable to the business model also. Now come to the academics. Yeah, some initial considerations for researchers is belongs to the okay academic IPRs. Who own the IPRs arising from your research work? Very important, because this is very very important for every uh, okay faculty working in universities or institutions. So because whatever you are doing, some research or some projects, some dissertation works, we should protect our ideas and our designs and our products. Understand? So who owns the IPRs arising from your research work? Very very important. See, so these things you have to remember. Check your university IP policy. This is I already told you. Okay, so there is some policies in every university or institute regarding the intellectual property. You have to read carefully before claiming. Make sure you keep detailed notes of your research work and and yeah, here here you can see submit an invention disclosure form whenever you feel you have discovered or created something unique with possible. This is very important. Commercial value. Understand? Don't publish. Don't publish your research before it is protected. That is very very important. You keep it in mind. If you publish, then you don't have right to protect using the IPR. So before publishing your research, we should protect our product or our research. Okay, research patent or literature, it's a main of business and technical information. Check how license reserves are to be distributed and what share you will have, because depends upon the IPR policies of your institutes, these things will may change. Okay, understand? So now go to the business again. So like this, okay, similar manner as individual business models, also you have to do some patent or you have to do some certification, then you have to do some research whether it is the market or not before going to the licensing. Then only you have to do the patent. The once you patented, you should be able to do okay output from your patent. Okay, so this process same. Similarly for the academic also, right? Now come to the what is the university's commercialization strategy. Very very okay. These things I already told you. Okay, next before going to patent, I already told you you have to search in the IP database whether it is any product similar products are patented or not. Then only you go to the patent, right? So what are the rights and obligations? Very important. I already told you these are the rights and obligations, and discover your patent. Yeah, 6 things to know about patents and utility models. Very, very important. One, your invention must be new and different from a legal perspective. So before going to IPR, we have to do some research. Move fast. Why I am telling move fast? If you go very lazily, or if you go okay, if you take more times in between in some the meantime, somebody will file the same type of product or okay idea. If they patent, so your product or your idea will be invalid, right? So we should be very fast. With these rights, you decide who can make, use, important, or sell your invention. Okay, so you can license and you can use directly or you can sell it your license. Okay, these rights do not give you the freedom to commercialize your offering. Someone else may have IPRs on other aspect of your offering. That because okay, once you patented me, same type of features or same type of service can be given by some other also with a different product also or different in a different idea. Understand? So don't think that your services are patented, right? Not a one-time cost. Very important, you keep it in mind. So I already told you for any IPR there is a limitation or a limit for the duration of time it is valid. Understand? So its time is valid up to depends upon the okay how you are filing for lifetime means it gives. I will show you that values also. Okay, duration of time. Understand? Now, next one is claim matter. Where you have to claim the matter. What you claim in your application. Very, very important. Whenever you are filing a patent, you should be carefully mention your objectives, your inventions, your idea clearly. Clear cut objective point should be there. Okay. So this is about the different types of patents. Understand? So you can here I divide the patents: individual patents, business patents, academic patents. Again, we have different types of IPRs, intellectual properties, right? I already explained. Next, you go to the okay. I will explain one by one. Okay. Next, technology and innovation. Okay. What is the technology? See here I already told you one is first one is patents, next utility models, then defensive publish, defensive publishing, right? So protect your patent. Yeah. Question to ask before patenting. Very important. I am asking simple question. Is there a market for my technology? That you have to question yourself before going to patent. What you have to do? We have to question ourselves. That first question is there a market for my technology? Do I own my invention? How much will it cost? Very important. Suppose if you spend 100 rupees, okay, producing some product, okay, if you sell it 10 rupees, so it may you may not get the profit and you will get the loss, right? So that type of ideas won't work for the business, right? So you should careful about this one. Do I want to publish disclose my invention to obtain patent protection? Yeah, you have to decide. So all these things be will have to decided by the who are going to file the IPR. What commercial value will my patent or utility model provide? Very, very important. I already told you. Commercial value means business. So what, how much cost it will take to, okay, produce, okay, next, how much you can sell it. All this will be come into picture. Understand? Next, if you want to see the IP valuation, I already told you. See, these are the three important points you have to keep it in mind. One is cost. What is the cost? Value calculated based on developing a similar asset. So you have to estimate the cost of the idea or product. Next, market. How much market is there? Okay. So in the world or in any business model, then come to the income. How much income you will get? You have to expect you do some calculations, right? So like this you have to do. Next, brand. Very important. First one is the patent. Okay, so we know that how to do the patent and all these things I will tell you later, okay, one by one. So so your patenting means you are giving some certification to your work or idea. So this time and limited country specific rights, very important. Time limited, it's not for lifetime. So what is the time limited? 20 years for patents, 7 to 15 years for utility models, and it is country specific. So this, if you file any patent in India, that may not applicable to the other countries, right? So every country has their own patent offices. Understand? So if you want to do any business in another country, you have to patent there and you have to get the certification. Then you have to, okay, do the business there, right? Next, yeah. Next, creative. Creative contents mean like your research. Very simple. A copyright. You can copyright your book. You can copyright your okay, any publication. Okay. So like that, this copyright, what it does? Copyright protects original works and gives creators various rights. So it will give rights to you over their work for a limited period. So for any, you see, in the intellectual property right, it is a time bound. It is not for the okay, lifetime. That means it will work for 1000, 1000, or 100 years. Okay, there is a limited of time for any certification. Owners of a copyrighted work can authorize or prohibit use by others. Why you have to do copyright means use by others, you can protect from the use by others, reproduction in various forms, distribution of copies of the work. So you should not distribute your copy to others without intimation to the concerned person. Public performance, so you should not give, okay, easy access to anyone. Broadcast or other communication to the public. Translation, we should not do any translation without giving the without getting any permission. Next, adoption, right? So duration of right, this is very important. The lifetime of author plus 50 years at a minimum. Okay, so lifetime of author means suppose if you survive up to 60 years, so this will be valid up to that plus 50 years at a minimum. So 60 years plus 50, that means 110 years it will be copyrighted. Works that are no longer subject to copyright protection enter the public domain and anyone can use them. Understand? Some of the original works copyrights protects. These are the different types of ideas or works we can be copyrighted. So we already know about books, lectures, speeches. translations. So even plays, musics, dance performances, and music. Okay, films. Yeah, all movies are copyrighted. Okay, understand? Even some videos in the YouTube videos. Understand? So anything, if you create something new or if you create something novel, so that you can take it as a copyright. Understand? So mobile apps, original database, all these things can be copyrighted. Understand? Now come to the brand. Very important. Trademark. I already told you. So trademark is the signature of any company. Okay. So if you see a company, okay, they have the trademark means so that is belongs to that company by saying, suppose if you see the Apple symbol, okay, anywhere, okay, Apple company symbol, so directly we can say that it belongs to Apple company. Okay, if you see HP, that indicates directly you can see that it belongs to HP company. If you see Dell means it belongs to Dell company. So like that they have some logos that are trademarks. Okay, so next, you can do confidential information also. You can protect your confidential information also with a trade secret. So what qualifies as a trade secret? These are the three important points you have to remember. Information that has commercial value because of its secrecy. Okay, so most of things are formulas, any research formulas, okay, any product formulas that are secret information, right? Confidential information. So they can do this intellectual property right. Under intellectual property right, they can do some certification in the form of trade secrets, right? Information that is not generally known within the relevant technical or business field, where the holders of the information takes reasonable reasonable where the holders of the information takes reasonable steps to keep the information secret. Okay, so these things they will take care about once you do the confidential information and under trade secret. Next, designs. Yeah, we can do this designs, any design, any building design or any, okay, device design. Okay, so that also you can do some uh, certification under design patent. Under design patent. So one is enhanced commercial value. So any income, so that is create revenue by licensing others to use design for a free. So stronger market position. Design is a key factor of in commercial success. Like any design, if you see, okay, it is a like Taj Mahal. Okay, all these are not patented, but the designs are automatically patented by the government. Understand? So strong market position, protection against influence. I will show you some figures also. Before registering your design, you have to do this. All these things I'll explain. So before going to design, you have to do some literature or some background work, and then you go to the whether your design is available or there in the database. You have to check it. Then you can go for the, okay, licensing, right? Next, last one is plant variety protection. So if you want to get into plant breeding, that means if you are going to develop a new breed, okay, so then you can go to plant variety protection filing. Okay, so what it means achieve a return on investment, invest to provide farmers with a new improved varieties that can respond to climate change and provide improved food security. Next, allow the public sector to target benefits for public good. Facilitate a partnership to achieve common objectives, share development costs, and promote marketing and distribution of resulting plant varieties. Maintain the value and reputation of their variety. Next, last one is be supported to work on a wide range of species and types of variety. Understand? So like this, you can do so many things. Yeah, now I want to show you some about trademark. Okay, about trademark rights. So what a trademark? Any sign capable of distinguish your goods and service from the those of other enterprises. And second one, what you can register. The possibilities are limitless. Words, names, letters, numerous drawings, pictures, anything, okay, under this Okay, you can register trademark. Renewable, okay, and country specific. Initial term is usually 10 years. Okay, initial term is only 10 years for any trademark. For example, if you see here, these are the example. So Coca-Cola, IBM, Airtel, okay, VI. So all these are trademark symbols. Okay, Apple. There is some duration. Okay, I already told you the duration is okay up to 10 years only. Again, they have to register. Next, four things. Yeah, this already told you. Next, yeah. So here, yeah. Here, I want to show some figures. Copyrights relates rights of performer. So A.R. Rahman has the right. They filed some right on the copyright. Okay, for his performance in the okay other countries, and right of producers of sound recordings. If any unique sound that they produce, they can okay file the copyright, and right of authorship. Okay, right of broadcasting organization like TV, FM, radios. Okay, so they have the some rights. Next, geographical indication, very very important. Geographical indication means whatever the product belongs to that area, geographically related to that area, any product or any monument or any unique thing is there. Okay, then that will become under geographical indication. Is an indication which identifies goods as agricultural goods, natural goods, any goods, manufactured goods, okay, or manufacture anything where a given quality, reputation, or other characteristics of such goods is essentially attributed to its geographical origin. So it belongs to a region. Understand? In case of manufactured goods are one of the activities of either the production or processing or preparation of the goods concerned take place in such territory, region, or locality. It belongs to a region or locality. For example, if you see here Tirumal Laddu, so it has the geographical okay identification. Basmati rice, Darjeeling tea, okay. Nagpur oranges, you can see here. Okay, this is a Darjeeling tea. Okay, Kanchipuram saris. Like that, you have so many. The term of geographical indication production is 10 years only. Okay. Next, come to semiconductor integrated circuits layout. With this also we can do okay designs because it is a design, right? So this can be come under IPR, intellectual property right also. These things. Suppose if you design a new circuit and if you printed that one, so you can do some certification on the design in under semiconductor integrated circuits layout design, right? Okay, so this is the duration of the production in years. Life of the inventors or who filed this one plus 50 years or 50 years, 20, 15, 10, like this it will be there. Next, if you want to increase this, okay, if you want to renew it, you have to pay the additional fees. So at the end, I want to show you the what is the structure of the intellectual property office in India. The Controller General of Patents, Design, Trademarks, all this will have divided into four parts. One is Patent Office, Patent Information System, IP Training Institute, Nagpur, Trademark Registry, and GI, Geographical okay, Indication Registry. It is located at Chennai. So the Patent Office head office is at Kolkata. Okay, there is a design office at Kolkata. Okay, next there are another some head offices at Delhi, Chennai, and Mumbai under the patent office, right? Next, patent IP and training institute you can see it is there at Kolkata. Next, trademark registry also you can see head office at Mumbai. We have another its regional office at Delhi, Kolkata, Chennai, and Ahmedabad. So like this is a structure of the intellectual property office in India. Okay, so this is the last I want to show you what is the patent flow chart. First you have to file the patent with the provisional specifications, then filing complete specification within 12 months after provisional. Okay, if it is yes, then go to the publication, or directly we go for filing a patent with complete specifications, then also we can go for publication. Then we have to come to the pre-grant okay opposition. Okay, can be filed within okay, if not if you are unable to give this means then it will be abandoned, so then you have to end it. Then If you pre-grant approval, then you request for examination for the grant. Okay, so within 48 months from the date of priority, it will be completed. Then we go for the examination, patentability and other requirements under this act. Okay, then if you have to go to the FERU issued, if you issued on your patent, then expedited examination for startups and all these things. Then if it is no issue, then you will come to the down. Application is to be put in order by application within 6 months. So whatever you are filing, that will be filed in the order. So one by one will be examined. Then extended by 3 months. Up to 3 months, they will be keep with them. From issuance of the FER, okay. Then you go to the, if any objection is there, not met within 6 or 9 months, then it will be abandoned. If somebody already filed or something, okay, they will file, they will see any objection, then it will be abandoned. Otherwise, you can go to the objection within 6 to 9 months, then grant will be, okay, released. Understand? So this is the flow chart of the patent. Okay. If you have any doubts, please contact me through this mobile and email. Thank you.